Good day to you and welcome to another Paddocks Club video tutorial. Today I want to deal with some comments on conduct rule number 6, which is entitled Signs and Notices. Before I start with the comments, I'll just take you through the text. Conduct rule 6 says, no owner or occupier of a section used for residential purposes shall place any sign, notice, billboard or advertisement of any kind whatsoever on any part of the common property or of a section, so as to be visible from outside the section, without the written consent of the trustees first having been obtained. Now, this is one of the rules that can be altered by the developer on the opening of the sectional title register, but it seldom is in purely residential schemes. Thereafter, of course, it can be altered by special resolution of the body corporate, it being a conduct rule. In mixed schemes, very often there are signage rules. Because this rule refers only in its text to sections used for residential purposes, it doesn't apply those put to commercial, retail or other non-residential purposes. When the trustees of a residential scheme are first asked to consent to the placement of a sign, they should develop a policy after talking to owners, and that policy should then apply to any request that follows, to the one that they're dealing with, of course, and any following ones, so that there's uniformity in the way in which the trustees interact with owners in regard to signs. For any non-residential sections, one would expect that the developer might have made special rules, but the trustees, if they haven't, should promote the making of a scheme rule that sets out owners' rights and obligations in this regard, because it's a sensible thing to do. They should also bear in mind that town planning legislation applies to any signage that is visible from outside a scheme, so the trustees must be reasonably satisfied when they receive any application that this complies with whatever relevant bylaws there are, and they might ask the owner to give them confirmation in that regard. It is not unusual for developers to purport to give purchasers the right to erect signage, but because in terms of section 47(2) of the Act, no obligation arising from an agreement between the developer and any person is enforceable against the body corporate, the trustees must still ensure that any such signage is approved under this rule if it's for a residential section, or any other rule that may apply in the scheme. I mentioned that this rule doesn't give the right to the trustees to remove a sign that is attached to the common property or within a section where it's visible outside by a residential section owner or occupier if they haven't given permission. The trustees have no special right to move in and take off a sign that has been erected, but they do have the right, if they know that an occupier intends to erect a sign. A truck arrives at the front door, now we're going to erect a sign for Mr. X, who is a residential owner or occupier. Then they have the entitlement to step in and stop that happening. They can take all reasonable steps necessary to prevent the attachment of a sign if they haven't given permission. But once it's up, they're not entitled to remove it without a court order. Of course, an owner or occupier who has illegally attached a sign to the common property might not object if it's carefully removed and returned to him, but in most cases, this will be done for commercial purposes, and they may well object. They would be entitled, at least in theory, to approach a court for a spoliation order that forces the trustees to reattach the sign until a court has ruled on the legality of the attachment. Hopefully, one wouldn't go that route because the owner would realise that they were in the wrong and make an application which the trustees would consider. This rule also, I mentioned, doesn't apply to commercial signage rights that a developer may reserve or which a body corporate may wish to grant to non-owners. You know, the big Coca-Cola sign down the side of an apartment building or whatever it might be. These types of rights, because they're not held by owners, are in the nature of servitudes, and you're giving third parties the right to access the common property and that sort of thing. So those are different. If you have any questions in this regard, let's please discuss them in the discussion forum.